Welcome to War Story Wednesdays. Today I want to talk about a case where somebody's got more money than sense. Well, or just got greedy. Or maybe a little of both. This revolves around a mobile home park. Trailer trash, everybody's favorite real estate subject. Except this mobile home park is in Sunnyvale, California, the epicenter of the Silicon Valley. The sellers of this park decided it was time to cash in.
Well, this is all my money.
And listed it for $110 million. And they got an offer with a $3 million non-refundable deposit.
No, give me.
Hey, just hold that.
So these owners thought they were in great shape. They were going to cash out, all was good. Turns out that for a reason that doesn't make any sense to me, the sellers thought that it would be better for them to not be in contract at one period of time when the property was being reassessed, because they thought that the assessor would reassess it based on the contract purchase price rather than the then market value, appraisal price. So they convinced the buyer, who had already gotten 2 extensions to close escrow, to let the next extension lapse and that they would be able to come back into contract and buy it. And so that's what the buyer agreed to do. Some months later, the seller said, yeah, we've decided not to go forward. Oh, and by the way, since you didn't close escrow when you were supposed to in the first place, we're keeping the $3 million deposit. Thanks. As you might guess, the buyer was a little unhappy about the seller's position on that. Both because the buyer wanted to continue the purchase and absolutely because the buyer believed it had not forfeited the $3 million. So they sued. The Court of Appeal treated this something like a law school exam. Offer, acceptance, consideration, counteroffer. Did it lapse? Did it not lapse? What happens if the time is of the essence provision isn't invoked or is impliedly waived? All those kinds of things came up. And here's where the Court of Appeal landed. If neither party performs the contract on the closing date, the contract is deemed terminated. It's voided. And neither party has breached. And since there is no breach, there is no liquidated damage amount that can be imposed upon the buyer. Similarly, if there is no contract because it's been voided, then there is no non-refundability provision in a contract that would trigger the loss of that deposit by a buyer. And the Court of Appeal said, we like both of those answers in this case. The contract has lapsed, therefore the deposit must be returned. And there has been no breach of contract because neither party performed to trigger the performance of the other party. So here's what that smart seller in Sunnyvale could have done and earned $3 million. Tendered performance. All the seller needed to do was go into a title company, execute a grant deed, sign the escrow instructions, and give the purchaser 72 hours notice to perform. By doing that, the seller would have tendered performance, the buyer would have been in breach, and the deposit would have been forfeited. Here's a case where the seller outsmarted themselves and jumped the gun and didn't read their own contract. Well, that plus they got greedy, and the Court of Appeal said no. So what's the takeaway on something like this? Many, many times we are presented with a scenario where the seller wants to back out of a deal or the buyer wants to push the seller into performing the deal. And we're asked, what does the client need to do in order to trigger that performance? And it's called tendering performance in your own way, in your own right. Just last week, we had a case of a property in Tahoe with exactly the same scenario. And by tendering performance, by delivering the deed to the escrow company, the seller was able to push the buyer into performing or walking away from the contract so that the seller could sell it for more to someone else. As a real estate representative for either the seller or the buyer, you need to be aware of the trap of tendering performance, because it can work to your advantage or it can work to the other side's advantage. Be very careful. Pay very close attention.